Good day, everyone. I am Brian, moderator for this webinar. I welcome everyone for today's webinar, that is HIPAA Security Rule, Major Changes for 2025. I would now like to introduce our presenter for today, Brian L. Turtle. Brian L. Turtle is a certified professional in health IT, certified HIPAA professional, certified HIPAA administrator, certified business resilience auditor, certified information system security professional, with over 22 years experience in health IT and compliance consulting. I would now like to hand over the floor to the speaker. Over to you, Brad.
Thank you very much. Apply these standards because these are nothing but best practices. Quick history lesson. This regulation came out in 1996 under Clinton, known as the Health Insurance Portability Act of 1996. So HIPAA is a massive regulation. There's 5 titles to this thing. Talking about being, quote, HIPAA compliant, you're talking about the HIPAA Privacy Rule, the HIPAA Security Rule, and the Breach Notification Rule. Those are under the administrative simplification. Why do we need these regulations? These are civil rights, these HIPAA laws, that you have a civil right to access your medical information. You have a civil right to control who can view your medical information. You have a civil right to know who has viewed your medical information. You have a civil right to the privacy and security of your medical information, and you have a civil right to be notified if there is a breach of that medical information. That's an extremely simple way of looking at this, but that's the gist of it. What's the difference in the HIPAA Privacy Rule and in the HIPAA Security Rule? Well, first off, the HIPAA Privacy Rule deals with protected health information in any form, paper, electronic, and verbal. The Security Rule deals only with electronic protected health information. The last real big change that occurred with the HIPAA Security Rule, or with HIPAA in general, known as the Final Omnibus Rule of September 23, 2013, equals the burden between business associates and covered entities. Any system that maintains medical information by law has to track what we do within it. It's to protect the civil rights of the data owner. Looking historically at the fines that have been doled out due to HIPAA, let's talk about business associate. A business associate is an individual or an entity that creates, receives, maintains, or stores protected health information on behalf of a covered entity or perhaps on behalf of another business associate. The new regulations coming around the corner, businesses need to do their own HIPAA security risk assessment. Here's where businesses are really hurting. Moving on from that, a little bit about telemedicine. If you do telemedicine, you need to be using a HIPAA-compliant telemedicine solution. A little bit on telecommuting. If you do telecommuting, you need a policy. If you're using wireless, working from home, make sure the wireless is, of course, encrypted. Don't use an open Wi-Fi. Ideally, if you do need to print paper, of course, that would go in a shredder. Common sense, a lot of this is more HR. There are 3 key changes to the HIPAA Privacy Rule. Now, these changes really do not affect business associates. This is only going to affect covered entities. Patients now have a right to use their personal smartphone. Eased identity verification prohibits covered entities from imposing unreasonable verification measures. Changes to fees, information sharing, and care coordination for providers and health plans. We need to create a requirement for these organizations to permit covered entities to disclose PHI to third-party organizations that provide health-related services, eliminate the need for the notice of privacy practices. By the way, the reproductive health care changes, there has been an injunction in Texas on this in federal court, so these things are on hold temporarily. HIPAA Security Rule proposed changes. So this is big. These are called Notice of Proposed Rulemaking. All right, these proposals aim to strengthen the current standards and implementation specifications. We need to update, well, they're going to be updating definitions and revising some of the implementation specifications to reflect changes in technology. Require greater specificity when conducting security risk assessments to include require notification of certain regulated entities, the strengthening of the requirements for planning contingencies and responding to security incidents. You have to do a HIPAA security risk assessment annually. Encryption at rest, as I discussed earlier. You've got to encrypt PHI at rest. Is going to be required, I promise you. Require regulated entities to review and test the effectiveness of certain security measures. Require group health plans to include their plan document. All-time high. I got to talk about cyber threats. Just in 2023, 133 million individuals were affected. There were even more in 2024. As healthcare is a giant target. Email is the Trojan horse, though. A little bit like World War III going on in the cyberspace. Don't go cheap on the technology, obviously, and educate the staff. Now, ransomware. This is the number one way data is breached. A ransomware attack, if it attaches to unencrypted PHI, again, is a breach. So information blocking, what is it? It's a practice by a health IT developer of certified health IT, health information network, health information exchange, or a provider that, except as required by law or specified by the Secretary of HHS, as a reasonable and necessary activity, is likely to interfere with access, exchange, or use of electronic health information. What you need to know are really the exceptions. Would not necessarily mean you would be fined here. So let's look at the 8 categories of exceptions. There are 5 exceptions that involve not fulfilling requests to access, exchange, or use electronic health information. And there are 3 exceptions that involve procedures for fulfilling requests to access, exchange, or use. All right, a little bit on personal device use, BYOD. Your number one compliance worry with portable devices is theft, encryption. So HHS put out a little information about mobile device use by your patients. This happened at the end of 2024. Patients now being allowed to bring their smartphones into facilities. So we, as it stands, this is nothing new. We cannot text medical information unencrypted. Not allowed. Appointment reminders. Make sure patients opt in for texted appointment reminders. The negatives are obvious. They're not secured. They sit on the device unless you delete them. The vendor keeps them. Trial attorneys are becoming a major, major problem because of all these breaches that are happening. Small providers tend to struggle more than larger ones under audit. And in conclusion, even with these changes that are coming around the corner, this is still a principles-based regulation. There's still nothing that's 100% perfect. That's all I have. I hope you guys enjoyed that for as much as you can enjoy a speech on HIPAA.
Thank you everyone for participating, and thank you, Brian, for the wonderful session. You all may have a great day ahead and have a happy weekend. Bye-bye. Take care.
Thank you.